Hi, everyone. Thank you for joining today's webinar presentation, A Conversation with the Commissioner, a look inside patent processes at the USPTO. I'm Allie Morton, Product Marketing Manager at LexisNexis IP, and we have a really exciting and informative webinar planned for you all today. Now, I would like to introduce our presenters. With us today, we have a stellar panel of speakers from the USPTO, including Drew Hirshfeld, the Commissioner for Patents. Drew manages and leads the patent organization as its Chief Operating Officer. He is responsible for managing and directing all aspects of the organization which affect administration of patent operations, examination policy, patent quality management, international patent cooperation, resources and planning, and budget administration. Drew received a Bachelor of Science from the University of Vermont and a JD from Western New England College School of Law. Along with Drew, we also have two other panelists joining us from the USPTO, Jay Kramer and Matthew Such. Jay Kramer is a Group Director in Patent Operations, who is currently leading an agency effort to modernize how applications are routed to examiners. He has previously served in a variety of management roles at the agency, supporting international programs, data analytics, and examination. Jay holds degrees from University of Notre Dame and Carnegie Mellon University. Matthew Such is also a Group Director in Patent Operations and is currently leading agency efforts to implement artificial intelligence for patent-specific use cases. He has previously served in a variety of management roles at the agency, supporting international programs, patent classification, and examination. Matthew holds degrees in engineering from Purdue University and Northwestern University. Also joining us today, we have Megan McLaughlin, the Product Director for LexisNexis Patent Advisor. After graduating from Harvard Law, she worked as a patent attorney at the law firm of Nutter, McLennan, and Fish. Her technical focus reached into a variety of industries, including medical devices, food industry, software, printers, and biotech. And last, but certainly not least, we have Jean Quinn. Jean is the founder of IP Watchdog, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean has been named one of the world's leading IP strategists by IAM Magazine. Thank you all again so much for attending today's presentation. And with that, I will turn it over to you, Jean.
My microphone is muted. Thank you, Allie, and thank you all for joining us here today for this webinar. We're really excited to have the Commissioner and his staff, Matt and James, with us here today. Again, we did a webinar like this last year, and it was a great success. So I reached out to Drew to see if he'd be willing to do it again. And he's always willing to try and talk to patent attorneys. And I've known Drew for a long time, and I think we're friends, Drew, right? And we have gotten to know each other. And the one thing I know about the Commissioner is that he really does like to talk to patent attorneys. He is really one of us on the 10th floor. He really cares about the patent system. And I think that that always comes through in his presentations and considerations of the issues. So it's always a pleasure to have him and his team here with us to talk about these issues. We have a lot in store for today. And what I'd like to do before we go through and start the substantive presentation of the slides is to, one, thank LexisNexis for sponsoring this webinar and sponsoring so many of our webinar series, because without sponsors, this is just not possible to do. We spent an awful lot of time putting this together, so thank you, LexisNexis. And then two, I want to bring the panel in and get everybody involved right away. Each person's going to have a portion that they're going to talk about specifically today, and then we'll have plenty of time for questions. But let's start with you, Drew, if we can. We're going to cover a lot of ground today. The big issue is, how do applications get routed to patent examiners, and how do applications get handled by the office? Which calls in so much of office process and procedure. But before we tackle that issue substantively, I always like to ask folks what it is that they would like the audience to have at the front of their mind, so kind of, wet their whistle or prime the well, if you will. So in, maybe 1 to 2 minutes, what do you think you'd like the audience to be thinking about before we begin the substantive part of the conversation?
Thanks, Gene. Well, I'm happy to jump in with that. Let me just start off by thanking you for the introduction, the very kind words, and for having us here. I'm going to talk, as you mentioned, the primary goal for today is to talk about the routing of patent applications, and we've got a great new system that we're implementing to address that. So I'm very excited to share that with all of you. I'm actually going to talk a little wider about some other ongoing topics of PTO. And then I'm going to talk about some changes that we have coming up October 1st, including the routing in my portion. To get specifically to your question about what I would want people to walk away from, I think primarily it's that we at the USPTO are always looking at ourselves to see how we can improve. And I think what you're going to see today are some changes that we're talking about that are to critically important foundational and fundamental programs that we have at USPTO that we are making changes and improvements to. So the one thing I would say is we are going to look at ourselves always and continue to make changes and improvements, and you're going to hear about some of those today.
Great, thanks a lot, Drew. James, let's go to you next, because I think in order you're going to be talking after Drew. What is it that you would like folks to be thinking about as we approach this big, broad topic today?
Yeah, thank you, Gene. Appreciate it. So I'll be talking and sharing some background on the new routing system that we're going to put in place. And so from my perspective, I'd like people to remember that we're about to engage in this updated methodology and this new approach to routing. That's definitely coming here, and we're going to talk about that. The change, I think as you're hearing the slides, keep in mind that this change will allow us to finalize this transition we have away from the U.S. patent classification system into our new cooperative patent classification system, or CPC. But as we make that shift, it was important for us to retain the expertise and institutional knowledge of our patent examiners who have been examining a certain technology and under a certain routing system. We wanted to maintain that expertise to deliver those same high quality patents we've always been able to do. So as we compare those two systems, keep in mind that this is what we're striving for.
Okay, great. Thanks, James. Matthew, I know you're going to be talking about a little bit about what the future holds and where the PTO wants to be going moving forward, which I think is exciting for what the future holds. What do you want people to be thinking about today as we start the discussion?
Sure, thank you, Gene. So I think we're all acutely aware that artificial intelligence has become this increasingly powerful tool that's been contributing to transformations ongoing in the economy right now. And the USPTO, we've recognized the potential value that AI can have on improving future agency operations and helping to strengthen the IP system. We are looking at artificial intelligence for a number of different use cases, and today I'm going to be focusing on our efforts for developing and evaluating an artificial intelligence-based auto classification system for patent documents that we seek to be able to utilize in the future. I'll be highlighting some of the development efforts that are underway, discussing some of the challenges with utilizing artificial intelligence technology and the approaches that we're taking here at the agency to overcome these challenges, as well as some of the potential benefits that we see on the horizon.
Okay, great. Now, Megan, last but not least, I want to give you an opportunity. I know you and I, we're going to sort of tag team the Q&A of the panel here together. And you and I, we've been doing, I guess, webinars on this topic. And I stutter there a little bit simply because it may be hard for some people to believe, but you and I actually talk about this issue a lot. And, we geek out about this issue a lot, to the point where when we're on conference calls, other people want to hang up the phone and just let us talk. What is it that you would like people to be thinking about as we approach this topic?
Yeah, so it's funny that this topic has always been very important to me. And Gene, we've said this before. I feel like classification is probably the most important strategic step in prosecution that most practitioners aren't thinking about. I think most of us just take it for granted that if you file a patent on some technology, that it's going to go to the right examiner. But it's actually really hard to do that. It's a really complex process. And the good news is that the USPTO has really been thinking about it. And I think that's going to come throughout this presentation.
Yeah, and what I'll say is just my 2 cents before I turn it over to the commissioner here is during our pre-call, as they were laying out and they meaning Drew, James, and Matthew were laying out what it is they wanted to talk about. My eyes opened like saucers, and I thought to myself, "Oh my goodness, this is going to be potentially 1 big and 2 very, very good." So I'm really excited. So let's just jump right into the substance. And before I do that, one last housekeeping thing, just for everybody who's here. Now we have well over 600 people with us live at the moment. If you want access to these slides, you can get them right now on the handout section on the GoToWebinar control panel. If you are listening to this online, you can download them. Everybody will get access to the slides and to a recorded version of the webinar. And since Ali said this at the beginning, we've had several hundred people join us, but we'll be giving codes out for CLE purposes throughout the webinar periodically that you'll need in order to claim CLE credit. So when the appropriate time comes and we're going to release those codes, I'll have Ali come back and join us and we'll go over that again. But that's it. So Drew, where should I go here? I guess this slide is a good place to start.
Yeah, that's great, Gene. Thank you very much. As I mentioned in my opening a couple minutes ago, I'm going to talk about a variety of topics before we drill into the classification topic that mostly Jay will talk about, and then the AI that Matt will talk about. I wanted to give you all some background and address some other changes as well. So I'm going to start with the blue box that you all should be seeing on your screen. I wanted to give you some background about staffing, and as the USPTO as a whole, you know, we're about 12,600 people. Within the patents organization, we're at about 10,000 people with just about 8,100 examiners. So when you think about classification and the various applications that come in, we'll have 450,000 approximately new applications filed in a given year. So getting those thousands, hundreds of thousands of applications to those thousands of examiners in 9 technology centers and over 600 art units is quite the challenge. You heard Jay mention before about making sure whatever we do takes into account the examiner's experience. Our average examiner has just about 12 years of service with the USPTO, and that is quite a fascinating number, especially when you look at how many we've hired in the last few years. So I think with even notwithstanding a whole bunch of new examiners, we have still 12 years of experience on the average examiner. And about 40% of those have some sort of advanced degree, whether it's a law degree or a graduate degree. So quite an educated staff as well. I'm going to switch to the green now, and I included this slide because I wanted to give some background on our work at home programs, especially since we are virtually, we're almost all at home right now. As you're probably well aware, sometime in March, the PTO went to mandatory work at home, where everybody needed to be at home during this pandemic, but for some critical employees whose work could only be done on the office, such as IT systems, things like that. And now we're actually in a state where we're calling it maximum telework, where we are encouraging people to be at home. And honestly, it's almost the same as the mandatory. We're letting people come in, but what we're seeing is we have about 100 employees at any given time are in the office, and that's a minuscule number when you think about the numbers that we really have. So we are essentially working at home. Now, before, the slide that's on the screen actually represents the telework before the pandemic. So you can see that full-time teleworkers, we had about 6,400 of them out of the 10,000 or so employees within the patents organization. And going to it's like an orange box, you can see that part-time teleworkers were about 2,400. So that's a huge, when you put those numbers together, that's a large majority of our staff was telework ready in some form, either to be able to work full-time or part-time, but they had the equipment, they had the ability. So when we switched over to mandatory telework due to the pandemic, we were in a good place to continue working. and to continue to be functional for all of you, right? For all of our users. We had just, over 1,000 people where we had to get equipment and teach them how to work remotely, and I feel like we did that as seamlessly as can be. I'm really proud of my staff, honestly, of the way we transitioned to this, because there's a lot to work out in situations like this, and I feel like we did this very well. And we've heard from our employees that they appreciate the way we've transitioned and got people equipment and information about next steps. One of the questions I get asked, and one of the reasons why I wanted to show you these slides, is I get asked about examiner productivity. Are examiners still working? Are they producing? And I will start anecdotally and just tell you that I hear routinely that people are very thankful that examiners are still working. They're finding them available. They're able to have interviews. They're able to contact them. I hear that routinely in my interactions with people from the public. But we also, of course, do track our work product, and we're actually slightly trending at a higher productivity than what we expected for the year. And of course, what we expected did not include any changes for the pandemic. So when we looked at the year and planned, and we of course did not plan on a pandemic, we are actually trending slightly higher in the work amount of work, the work product that our examiners are producing. Now, I'll be the first to say that that's a very misleading statement that I said, not intentionally misleading, but what I'm getting at is while that is absolutely true what I said, what's happening, like companies throughout the world actually, is employees are not taking leave. They're not taking vacation time, annual leave. So we do know that employees are building up large amounts of leave because they're not taking them. So part of the reason why we're able to produce to the level we have been is because people are actually working more hours than they would under normal situations. The reason why I said it's misleading is because we are likely to have a latent impact here when the pandemic is in a place where people feel like they can take leave and take vacations. We're likely to see a drop off in productivity, and that's something we're well aware of. And again, I don't think this is unique to USPTO. I actually think this is consistent with what everybody is seeing, and people are not comfortable necessarily taking vacation, so they're staying here and they're working. So that is why we are trending a little bit higher. So with that, Jean, if I think you've got the slides, if you can go to slide 4, please.
There you go.
Thank you. So I wanted to also address our filings. People are always asking about filings, especially now. So if we go to the blue box, what you can see on the screen is that for new cases, new filings, so serialized is the way we refer to new cases, basically, but our new case filing through the end of June for the year is up compared to last year about 1.4%. I often hear, filings are tanking, filings are going down, and it is at 1.4% since the start of the year, which I think is a pretty healthy number. Now, before March, we were actually trending at about a 4% increase as compared to last year. So there has been a decrease. So if we look at the numbers from March to the end of June, we are seeing a decrease compared to last year, and it's a decrease of about 2.5%. So there has been a decrease related to new filings. It hasn't impacted us from the year-to-date standpoint in the sense of actually being less than last year, but it is a decrease, a little bit of a decrease in the time of the pandemic. We are actively watching that, as you can imagine. As obviously as a fee-funded agency, we need to make sure that we're able to sustain ourselves, and I think we're in a good place, but we are actively watching this. I'll also point out that one of the areas that we're focused on, or issues that we're focused on, is that historically the patents filings and revenues, and I'll address revenues in a second, but the patents filings and revenues have been lagging indicators of impacts to the economy. The trademark side of the house is a leading indicator. So when there's changes in the economy, they usually have immediate impacts. On the patent side, it is usually a delay. And I am hearing from many people that they're concerned on the outside about their budgets and potential cutbacks to filings they can do. So we are actively watching that as well and being very cognizant that for the patent side, we could actually see larger impacts down the road than what we have now. Your guess is as good as mine. I don't know if any of that will happen, but certainly that's something that history has shown that we're a lagging indicator of changes to the economy. I mentioned fee revenues, so I'd like to discuss that. A lot of people are asking, about our revenues. Are our revenues okay? We are seeing a slight decrease in the revenues. We're down about 1.5% from what we had projected for the year. I have no doubt that some of that is just, less either maintenance fees or filings, less revenue coming into the PTO. Some of that is also related to some of the relief we gave where people could delay some of the work that they were doing. So I have no doubt that both are playing in, but we are trending about a 1.5% down. Now we do have a over $3 billion budget, so that's a large number, but percentage-wise, it's at 1.5%. I included on the slide for your reference the total applications. I include that because it's just mind-boggling that at any given time there's over 1 million pending applications that are going on. I thought you would find that interesting. Over on the green box, I'll go quickly through this, but I just want to give some background. We all have been watching pendency always, those of us that are immersed in the patent field, and our total pendency is averaging 23.1 months. That is going down, but the purpose that I have this slide is, the purpose that I have this in the presentation is that I really want you to focus on the second outdented bullet, the patent term adjustment compliance. I would like for all of us to have a much greater focus on compliance with patent term adjustment than average pendencies. Average pendencies are great if you're at the average, but they're not really helpful if you have an art unit who's not at the average, swaying either way. It could be much faster, could be much slower. What we'd like to focus on, and you'll see a transition to a greater focus on this, is our compliance with patent term adjustment. So we have, of course, statutes which tell us how quickly we need to do our work, and if we're not, doing a first action in say 14 months or responding to an amendment in 4 months, we award patent term adjustment. We would like to be compliant both in the cases we mail and both in the inventory. We feel that's the best measure of consistency throughout the office. We feel it's the most clear to our applicants, the best for the patent system. So that is something you'll see us focus on. We have a 5-year goal to be 90% compliant with all patent term adjustment timeframes. And again, that's for not only the cases in the inventory, but also mailed cases as well. We're currently about 84% of mailing and 88% of our inventory is compliant with those timeframes. Again, I highlight that just so you'll know where we're focused on that. Going to the orange box, I did want to just point out our allowance rate is about 60%. And then I have the appeal information there. I have this because people are interested in it. I will tell you, we don't have goals of allowance rate. We don't even have goals, honestly, of an appeal affirmance rate or not. We want examiners to make the right decision based on a case in front of them, what they believe is the right thing to do. We don't want people shooting for a goal one way or another, but these are numbers that nonetheless people are interested in. They are certainly interesting numbers, but wanted you to have them as well. Okay, with that, Jean, I can go to the next slide. Okay, now I'm going to get into a little more of the big changes that we have coming on October 1st. And in my opening remarks, I talked about fundamental or foundational changes that we're making. And if you go right to those dashes on the screen under the second bullet, you can see the changes that we're making. And these really, when you step back, they really impact virtually everything an examiner sees on a daily basis. So when I say they're foundational, this will give you an idea of what I meant by that. First of all, we have been changing examiner time for many examiners. This actually started last year. We made some changes last October to examination time. and it will be making additional changes this October. Last year, what we did is we made two changes to time. One, we raised the lower end of the time that examiners get, so that some of these time changes actually haven't changed in 30 to 40 years. Some areas where the times were so low and the technologies have advanced that it just wasn't reasonable to do the amount of work an examiner needed to do in that time. So we raised the floor of time that examiners get in their production system. And we also created a new system where examiners would get time based on certain attributes of an application. So if an application had more claims, I think it's greater than 20 claims, or if there was a certain number of IDS references filed or pages of references filed, we would give an examiner more time than they have for other applications which don't have those attributes. That was our way to make the system more smart and more consistent with the amount of work coming in that an examiner has to do. We are making additional time changes this October, and for most people, it's going to be an increase in time. Basically, it's way too detailed for me to get into here, but I want you to be aware of it. But as you're going to learn in Jay's discussion, we're going to have a pretty refined CPC picture of every application, and we're using that to help us move towards the time that an examiner should get to examine an application. But my goal today is that you all recognize that we are making time changes. We are trying to update some times that have gotten out of whack and haven't really been updated again in many instances in 30 to 40 years where they were set. The second bullet goes to the performance appraisal plan. So I'm assuming most people know what a performance appraisal plan is, but every examiner, actually every employee of USPTO, me included, has a performance appraisal plan which outlines what you are supposed to be doing in your job, how you get evaluated, etc. We have made many changes to the examiner's performance appraisal plan, changes that will take place October 1st. And so that is a large change. These changes, there's again much to get into here, and I know that's not a goal. I want you to be aware of what we are doing. But some of the changes, for example, are an enhanced focus on the examination search. So we're really pushing search, making sure that examiners are doing the right search, and we have increased the guidance and goals for examiners in their performance appraisal plans with regard to search. We're also addressing things like having a clear prosecution record. We're giving them a better roadmap of how to write a high quality office action. So these are large changes that we feel are going to be very helpful in moving us forward to higher quality and to having a better and more effective and efficient prosecution. Some other changes that you'll also hear about are Count Monday will be going away after or sometime in October. I don't know the exact date, but in early October, Count Monday will be going away. That is one that seems to be the most interesting to practitioners because I know people pay attention to whether it's Count Monday or not, but we are effectively getting rid of Count Monday. I will tell you, I'm coming up to my 26th year at PTO. Count Monday has been a stressor for many people for as long as I can remember, and I'm sure well before I was at PTO. We don't want to put our supervisors in a situation where they have to review a lot of work at the end of a pay period, trying to get it in. And quite frankly, Count Monday was always a new day and a new bye week. Why we permitted work to be done that way for the previous bye week doesn't make sense to me. And so we'll be doing away with that. The bye week will end on Saturday. Supervisors can review the work after Saturday, and as long as it was handed in and it's correct, it will get counted for the time the examiner handed it in. Seems like a much smarter system to me. It takes the pressure off our supervisors. This way they can give the proper review and examiners know exactly when they have to hand in work. Seems like a much more clear system to me. So Count Monday will be going away. And you'll also see changes to examiners' docket sizes. What we're doing is we're going to smaller docket sizes with much more frequent refreshing of their dockets. So examiners will have smaller numbers, so this will help them work on first in, first out, but we will refresh weekly an examiner's docket so that they won't run out of work. We actually piloted this and we saw some really good results of the pilot. So that is generally what I wanted to say. Gene, I have a number of slides after. I actually talked right through them on this slide, but you can advance just so I can explain what they are. You can advance to the next slide here. So this is what I talked about with the time changes. Again, these are for your reference, but I talked about all of this already. Gene, if you go to 7. Next one is the performance appraisal plan. And then you see the application routing. And we can pause here for a quick second. I am thrilled to have 2 of my colleagues here, 2 group directors. One of my goals moving forward is that I get some of the really smart and great employees that we have at USPTO out to talk with members of the public. And I know you know people hear from me a lot, you hear from the deputies a lot, and we've got great people behind us and working with us, such as Jay and Matt. And so I'm thrilled to have them here. So when Gene reached out to me and asked if I would do this, I was very happy to do this and share the great work, but I'm really thrilled to have Jay, who's going to walk through the routing that's going to take effect on October 1st. And then Matt will talk about a more aspirational view of artificial intelligence, as he said. And I'll just reiterate that Matt's portion is not slated to take impact or to start any particular date. That is something that we're still working on, again, more aspirational. So that is what I wanted to share, and I'm happy to take any questions, Gene, if you want to do that, or we can wait to the end, whatever you think is best.
Well, we could probably do a couple questions right now. There's a couple, at least quick questions here I see about when the public search room might reopen, and then when the copy room might reopen so file wrappers could be obtained. And I don't know whether you have any information on that, or are you in wait and see mode?
Yeah, so we're definitely in wait and see mode. Like everyone else in the country, we are reopening in phases. We've gone, as I mentioned earlier, from the mandatory telework to the phase 1, which is maximum telework, but still some people can come in. I wish I had a better answer in terms of a date, but I think for the safety of everybody, we're taking an approach of a wait and see. We're working with local officials. And so I don't really have those dates because we don't have them yet. And as we're monitoring the impacts of the pandemic and the changes, we will of course have more specific information as it's appropriate.
And then another potentially quick one might be here is, have you looked at the filing trends of small versus large entities? And one of the, because I found it interesting what you were saying about the decrease, the 2.5% decrease, which is, you know, is meaningful, but it is small. And I've heard from a number of patent attorneys that, you know, what you would expect in this type of situation, the large companies, they hunker down. They always seem to research and develop less and patent less at these types of times. And then but the small companies and the individuals are really going to town. And I mean, I see a lot of activity there. So have you looked at that and see whether there is that disconnect or difference?
Sure. So I don't, at the tip of my fingers, have that information. So I don't know that, and I will certainly take a look into that. I know for a fact we have people who are analyzing all of our filing trends for large and small, for everybody, and it's part of the analysis we do to help us predict what our expected revenues and filings are moving forward, but I don't have those. I'm more than happy, Gene, to follow up with you on that, though.
Yeah, that would be really interesting, because, you know, what I'm hearing is, and the 2.5% decrease number did not really surprise me, because what I've heard is that, you know, firms have clients of all different sizes, many of them do, and the larger entities are hunkering down, but that what I've heard in a lot of cases is that the smaller entities have made up or almost made up the difference. And that if that's really what's going on, then I think that is really good news for the future in America. And that's really what you would normally expect. Maybe not, pandemic is hopefully once in a lifetime, and once in many lifetimes, hopefully. But with these types of, and I know we're probably not technically in a recession, but you see in recessions or pauses in economic activity where creative people take that opportunity to create. And so there may be a silver lining message here. So if you could, that'd be wonderful.
I'd be happy to, and you're raising a number of good points. I will tell you, in the last, say, 20 years, I think every year except for one, there's been increased filings compared to the previous year. So while those numbers are small, and they've ranged, in anywhere from 1% to 4 or 5%, but we've always increased. I think it was 2000, it's either 8 or 9. I think it was 2009, where we didn't have an increase based on the previous, or compared to the previous year, and that was after the financial impacts of 2008.
Yeah. So Megan, do you have anything that you'd like to ask Drew at this point before we turn over to James?
There is one question I wanted to surface, and I know this isn't our topic for today, but I think a lot of people are interested in the way that you're changing examiners' dockets. So by reducing the size of the examiner's docket, does that mean that an application just sits longer, on the backlog before it's being assigned to anyone? Can we expect longer times then before an examiner is assigned?
Right. No, it's a good question. So the answer is no. What you're going to hear from Jay, and this is a great lead into Jay's conversation, what you're going to hear is that with the smaller dockets, and I don't want to be, I want people to understand that we're not just saying smaller dockets and comparing that to today. It's smaller dockets with more frequent refreshing, so that examiners will constantly have work. There's no way an examiner will run out of work. By the way, we get asked of examiners too, because of filing differences, are we running out of work? But PTO is very far from that. We're nowhere near that. But to answer your question, Megan, cases, we will be, with the routing scheme that we're putting into place, not only will we be able to better match the technology to the right examiner, but we'll be able to do better workload balancing. So I think this is a game changer for us in terms of making improvements to pendency as well as quality by ensuring that the applications get to the right examiner. So, if you think about it, we're not increasing or decreasing the amount of work in the door. So if we had large dockets for examiners, cases could potentially sit on the examiner's docket for a long time. What will happen is now with smaller, more frequent refresh, nothing's going to sit there because they're going to have to do what's on their docket, and we will have the ability to see who needs work, where are the best, where are the low points, so to speak, in terms of backlog, and we can divert the work there as long as people are qualified to do that work. And that's what Jay's going to get into in his discussion.
So can I follow up on that real quick? So does that mean, because I've been a fan, I think, as you know, I think we talked about this, compact prosecution. I've always thought that if examiners and attorneys too, and agents were working on applications in a more condensed, over a more condensed period of time, that you'd get better institutional memory on both sides and a better, quicker outcome. Is that what you're trying to accomplish with this?
So you and I have talked about this, and I'm actually a complete fan, like you are, of being able to address that issue and have a more real-time back and forth throughout prosecution. That being said, I don't think that the changes, and certainly Jay and Matt, if you feel otherwise, chime in, but I don't feel these changes really address that issue.
Okay.
These changes will make sure that we are working the first in, first out in better order. They'll make sure that we're getting the right case to the right examiner. And again, a key component of that is also workload balancing. So for example, if we say, okay, these 5 examiners are all qualified for this application, we'll be able to see which, who needs the work the most, or who can turn that case around the fastest.
Okay. All right. Fair enough. Megan, are we ready to move on to Jay?
Yeah, let's go.
Okay. Well, thank you, Commissioner. I really appreciate that, and look forward to having you stick with us. And if we have some time at the end, we'll sure have some more questions for you. But Jay, I think the floor now is yours.
Thanks, Gene. Yeah, so I get the unenviable task of following Drew. Never fun, but I'll do the best I can here. I'm going to talk a little bit about some changes that are going to come to the USPTO with regard to how we route applications. So before we jump right into that, I'm going to start with some background slides. So if we can advance to the next one. I'm going to talk a little bit about classification. I always compare classification to just to make it simple, to like a Dewey Decimal System that everybody learned in elementary school in the library. And it's just a way of assigning a number to an incoming document. In the case of a library, they assign a number to a book. It's based on its topic. So if it's a book, a nonfiction book on trees gets this number, a fiction book by this author gets a different number. And it's just a way that you can find things quickly and easily. You can group documents together. So all nonfiction books by trees can get put together in the same place in the library, and it makes it easy to find. At the USPTO, this is what we do with incoming applications. They come in, and based on the underlying technology that's within the application, we assign it a number. We call that a classification symbol, and we use this classification for a lot of things. And you can see from the slide here, we group technologies together. We match that technology to an examiner, and we use that technology to assign time. So that's how much time the examiner is allotted to work the case. And then, of course, it's used primarily for search and retrieval as we look to make office actions and make patentability determinations. So if we could go to the next slide. This is kind of the milestone moment, I guess. The watershed moment was in October of 2010. We signed an agreement with the EPO in order to change from what was our US patent classification system to this new cooperative patent classification. It's a significant step towards harmonization, specifically as it stands today. Well, in terms of harmonization, if you think about the future being versions of work sharing between offices, and PPH is a pretty good example. So a case gets allowed in one agency, and an applicant files a PPH petition in another agency. The second agency can use some of the work done by that first agency. We can look at file wrappers, we can look at searches. So having a shared classification system, one where we can more readily understand and maybe interpret the search done by another office, will help us to achieve better harmonization of our searches and our work. So this new going to a cooperative system does help harmonization. I looked this up before this meeting, and as of now, it's close to 50 other IP offices have now also come into CPC. So it's not just the USPTO and the EPO. Many of the EPO's member states are also using this. Korea's converted to CPC. China's converted to CPC. So like I said, many worldwide agencies are using this. And lastly, it is a more flexible system. We'll talk a little bit about that in a minute. And it is more up to date because we're committed with other agencies. We're routinely keeping it up to date and modernizing it. And that's the thing, all of a sudden you get a new technology, you need to update your scheme to capture that. That's part of what keeping it up to date means. So the next slide, I'm going to go into some of the differences between what the U.S. patent classification, which we call USPC, and the cooperative patent classification, which is CPC. So this is an important slide. I'll spend a little bit of time walking through this so that you can understand the differences. I think as you understand the differences, you'll understand the challenge we had in coming up with a new routing system. And I hope maybe you'll appreciate some of the elegance of what we've come up with as you understand the differences. So first, before I talk about the symbol, I'll talk a little bit about how it's a little bit of a different classification. I mentioned earlier like the Dewey Decimal System, but it is just a different way to classify the documents. An example that I kind of give, just a conceptual example, is imagine one thing where everything grouped trees by oak, maple, elm. And so anything that came in that had anything to do with an oak tree gets grouped into the oak category, and anything that came in that was a maple tree got in the maple category, and so forth. So imagine a second system that said, well, we're not going to group by tree type, we're going to group by parts of the tree. So it took all the branches and puts all the branches together. Well, in the second system, you have oak branches, maple branches, but it's designed by branches. And so yes, they're both right. You have the same incoming thing, but in one system you put all the pieces of the tree by the tree type, and in the other one you'll put all of the pieces of the tree together regardless of the tree type. Still the same, but just a different way to group the documents. And conceptually, that's a little bit of what the change. That's an easy way to think about how the differences between two classification systems. We still have the same applications. We're not changing what's coming in. We're not changing the expertise of the examiners. We're just grouping the documents a little bit differently. And so that does present a challenge, as I mentioned earlier, and Drew mentioned, in terms of we want to maintain that intellectual expertise of our examiners, but we have this different grouping of cases. How do we go about maintaining that? And that was one piece that was very, very important to us, as I noted earlier, because it's really important. That's the fundamental and critical step to giving quality patent examination and ultimately making the right patentability determination. The second thing that was, and this is kind of a big one, and you'll see it too when we talk about what we went to, with the U.S. patent classification, we really only put one symbol on the document. And CPC relies on multiple symbols. You can put as many as you want on that application in order to capture whatever pieces of technology might be there. The example we like to give, again, a conceptual example is, you can have gears and you can have chemical components. Chemical coatings. And so in the USPTO, we have a gear area and we have a chemical component area. And when an application comes in that's a chemical component, a chemical coating on a gear, we have to pick either a gear examiner or a coating examiner to work that case. And there's sometimes a lot of intellectual exercise, a lot of delay in trying to work back and forth to understand what's the underlying technology, where does it go. In the future, because we can put now the CPC, both the gear and the chemical component, we can go try to find that right examiner who has the expertise in both the gears and the chemical coating. And we don't have to, it's not this backward, or it's not this offline sort of intellectual exercise. We can let the classification help steer it, again, to that right examiner, which again, we hope improves examination, brings better quality, memorializes that institutional knowledge. So I'll get into some examples of how this works in a minute. So let's go to the next slide. We've talked about a couple of these things, or we've definitely hit on these. Again, the goal, number one, we needed to shut off USPC. It doesn't make sense to maintain, from a cost perspective, two classification systems. It's a burden on examiners to have to understand two, one that routes to me, one that I'm searching or examining. And so really to relieve that administrative or that cost burden, but also really, and we've talked about this several times, it was a fundamental goal to maximize the retention of the expertise and knowledge of our examiners. That was the challenge all along, was how do we keep doing the same quality work we've always done, but route cases differently. So on the next slide, I'll start talking about some of the concepts and the way that we go about routing the cases. So if we can go to the next slide. So there's two ways to think about this. We've talked about CPC symbols or classification symbols, and we talked about how in CPC we can put more than one symbol on an application. And so what we call that combination of symbols, we call that the classification picture. And so when incoming application comes in, we assign it these CPC symbols based on the technology, and that becomes the classification picture on the application. In addition, as every time an examiner works on an application that has a classification picture, we can capture that information of what cases and what technologies they've worked on historically, and that becomes what we're calling an examiner's portfolio. And so I'm going to explain now a little bit more and give some examples of an examiner's portfolio just so you can understand how that concept works. So let's go to the next slide. So as I mentioned, it's a representation of an examiner's work experience. And so below you'll see the kinds of work. So anytime an examiner does a final or a non-final, an allowance, a quail, or an examiner's answer, the classification picture on those applications filters into a portfolio for that examiner, and we capture that every time they submit one of these pieces of work. And so I have sort of a little bit of a graphical example or on the next slide that kind of walks through that. So in this case, you have a single examiner who's done two cases. One is a non-final and one is an allowance. On the non-final, the classification picture had a CPC symbol A, a CPC symbol B, and a CPC symbol C. On the allowance, the application had that application's classification picture had CPCA, CPCB. In this case, it also had CPCD. So the examiner's done two count producing actions in this case with those symbols on it, and therefore that little box would become that examiner's portfolio. I guess that would be if the examiner had done no other work. Consider what would happen is that work would then attribute as an addition to all the other work the examiner's done, and it becomes like an addition. So the examiner would receive 2 additional, what we're calling tallies in CPCA, 2 additional tallies in CPCB, and then 1 tally in CPCC and CPCD. So again, you'll have this big table, and this examiner will have a combination of all these tallies, and that becomes the examiner's classification or examiner's portfolio. So on the next slide, I'll walk you through how we would take various portfolios and apply them to an application. So as you can see here, in this case, you have 1 application with 4 examiners. The 1 application has these 5 CPC symbols. So in this case, CPC A, B, C, D, and E. And we have examiner A, B, C, and D across the rows, or across the columns rather. And so the rows indicate how many tallies or how many work products those examiners have done with that classification picture. So you can see examiner A in this case has 45 tallies in CPCA, 32 tallies in CPCB, 21 in CPCC, 9 in CPCD, and 7 in CPCE. And if you compare him or her to the other 3 examiners, that examiner is the best qualified examiner to work that application. And so this is the kind of analysis that we can do, again, comparing these incoming classification pictures to every examiner's work product or examiner portfolio, and we can try to identify the best examiner. And so at the end of the day, what generally happens in situations like this, you'd see these, examiner A and examiner B probably are both very qualified. Examiner C is pretty close to qualified. And so when we do this across 8,000 examiners on a single application, we end up with collections of qualified examiners. And so on the next slide, we walk through some other things that we use once we have that pool of qualified examiners to sort of make, we call them sometimes tiebreaker or really fine tuning to get even the better examiner, right? Who has the most experience, the most knowledge. And these are some other considerations we use. And Drew mentioned earlier, right, the size of that examiner's docket. So again, we're going down to smaller docket sizes with more refreshes. So which examiners have openings in their dockets that need cases? We look at them with. We also look at when we say we can see for a certain application how many examiners are qualified, but you can also do the inverse, which is for an examiner, see how many applications they would be qualified to work. And obviously, if you had an examiner who has lots of other qualified work, we would want to prioritize examiners who didn't, so that we're not taking away. So again, we look at who's qualified to do, how many people are qualified to do a certain application, and then how many applications are each individual examiner qualified to work on. And then lastly, we do use some similarity techniques, things like cosine similarity, Euclidean distance, in order to match examiners to these applications. Again, once we find the pool of qualified examiners, we use these techniques to sort of fine tune it in on just that right examiner or that best qualified examiner. So that's really, I think that comes to the end of what I was going to talk about. That's sort of our new routing scheme. As Drew mentioned, this is going to start on October 1st. That's the start of our fiscal year. I think we'd be happy to take questions now if there are any.
Yeah, there's a number of questions there. Megan, do you have any question that you want to start with, or?
I mean, I think, and this is a little bit of a theme too, and this is something we talked about before the call, but I think people could benefit from hearing about it. So right now the way it works, right, is that the application gets assigned a primary USPC code, and then it gets routed to an ART unit, and then the C distributes it to whichever examiner in their ART unit they think is the best, right? So under this new system, it really fundamentally changes the function of the ART unit. Right. So what's going to happen to ART units? Are they still going to exist in their same form, or are things going to get switched up?
Jay, do you want me to jump in on that one?
Yeah, sure.
So it is a great question, because previously, literally a single symbol would be used to send an application, and then the SPE would have to try to remember, is it this person or that person who had the other expertise? And of course, that's not a workable construct. The construct is workable because we did it, but it's not a great construct. The construct we'll have now will be much more granular, and it will also be automatic. So you're right, it definitely changes the need for art units as we know them. However, in my mind, the primary reason for the art units is the training of the examiners, and the SPEs do an awful lot of training. And by the way, the SPEs are the ones who are training on all of these changes I've discussed today, the PAP, the routing, and the time changes. But the SPEs will be training their examiners on examination. They'll be there to answer questions. You'll have a balance of newer people in an art unit and more senior people who can also help. So I think the art unit construct, while not necessarily needed after October for classification in the same way as we've needed it, I still think it's very valuable for ensuring the right training and education of our staff.
Mhm.
Yeah, so the SPEs can, and we talked before, so the SPEs can focus on probably what they should be focusing on.
Right, and
training.
exactly. You know, the whole idea of this is that supervisors who might be spending a lot of time classifying or figuring out where the right cases go now will have that burden, so to speak, lifted from them, and hopefully be able to spend much more time on what their main priority is, and that's training examiners.
Right.
Yeah, the art unit becomes a lot more about mentoring the younger examiners from the SPE's perspective, it seems.
Absolutely.
Mm-hmm.
So
Yeah.
we have a number of specific questions here about how this mechanically is gonna work. From are you gonna, well, I mean, let's start with this one. Right now, the classification is done to some extent or facilitated by an outside contractor. Is that still going to be the case after this change?
Yes, so we actually have been having our contractors now starting to be prepared for this change and start to put symbols on in the broader way of the CPC as opposed to the singular symbol for the USPC. So we have been working with our contractors to do that. You're going to hear from Matt about some potential of down the road of using AI in this space. But for the near future and certainly foreseeable future, what we will be doing is continuing with the classifiers that we have, and as you said, they're mostly contractors. They will be putting the symbols on, and then when we have it, it'll be our job to say, you know, all this is done automatically. You know, we've got the symbols from the classifier. Now, how do we match that to the portfolio of the examiner and get those best matches that Jay was talking about?
So, and is that best matching going to be done in your office, Drew?
I'm not sure how to answer. I mean, it's a IT system that will do that. I don't know, Jay, if you have more there. It's not. Again, it won't be a person. It'll be done automatically.
Okay. All right.
Yeah.
Okay. That's fine.
Not going to move those servers into your office, Drew. Don't worry.
No. What I meant was, I guess what I meant was, so just it's going to be done outside of the art unit group or TC. So it's not something that like the TC can influence, so to speak.
Correct. It's
Yeah,
done.
no, I mean, one of the benefits is we'll be able to, like, as we're talking about, we'll be able to queue things and make determinations at an agency level rather than a TC, which we do hope will help improve pendency, because like we said earlier, things won't sit and stockpile in one art unit. We'll have them at a master queue across the core, across all of patents, and make those decisions. Okay, where should this case best go? Where's the best fit for it? So.
Yeah, and then I have one more question before Megan. I'll kick it back to you. There's a question about how it would be, the classification will be done. Is it going to be focusing on the claims, or is it going to be the entire disclosure, or do you have any more information on that, or is that still you finalizing how that's going to be done, or what can you maybe tell us about that?
Okay.
Yeah, so the original CPC classification, there'll be both types of actual classification on an incoming application. So the application under CPC will get a full classification picture of everything in it, from the claims to the spec to the background. Anywhere a technology is described, it will receive a CPC symbol. Then we'll take a subset of those symbols and identify them as related to the claim. And again, that's a fine-tuning way of really trying to find the best examiner, when you can identify things that the examiners both worked on in a claim set. That would be another way to sort of fine-tune that matching when we're trying to find that right examiner. So it'll actually receive both.
So yes and yes. Okay.
Yeah, if I
Good.
can add, that's some of the main benefit to what we're doing is we'll have a much wider classification picture, not only to the claims, but to the whole entire application, as Jay said, but tying back to our performance appraisal plan. And I had mentioned earlier that part of that plan was to have a heightened focus on the search. Part of what we are pushing in the search is searching the entire application, not just the claims, so that we're getting a more comprehensive search done for the applicant. And oftentimes we hear things like, well, I made a change and now the examiner says it's a whole new search. The whole idea would be we have broader searches.
Oh yeah, we've heard that one before.
These tie together very well.
Yeah, and I mean, I laugh, but I get it. Sometimes you file claims and you realize, okay, those are a dead end. Let's see what else I have in the specification. And examiners have a finite limit, a window, and the truth is always gray, is what it winds up being. But Megan, do you have any more questions for Jay before we move into Matt's segment?
Yeah. So this question came up, and we get this question all the time about how the old routing system operated, and it's about continuation applications. So when you file a continuation, is there some presumption that it's going to go to the same art unit, and now a presumption that it's going to go to the same examiner, or do you treat every new application with a clean slate?
Oh, that's a great question. So right under USPC, it does get routed to that same, it gets routed to that same art unit, and then the supervisor manually has to go in and make that determination. Oh yeah, I can see this person did the parent, I'll give it to that person. And again, in the future, that'll all be automated. It'll automatically get routed to the examiner who did the parent. We'll track all that. We have that data, and we'll make sure that happens.
So every continuation automatically goes to the same examiner by default?
That's what will happen in the future, yeah.
Okay. What about a continuation in part or a divisional?
So divisionals can go to different examiners, and as we said, that's actually tying back to the question Gene just asked. That's an important part of understanding a distinction between claims and just specification. So assuming the divisional came in a way that the classification picture, in particularly the claimed classification picture, changes, those could get routed to a different examiner. I'd put the continuations in part in the same boat. It depends on the breadth of the change and what it does to the classification picture.
Okay. And then the other. Oh, go ahead.
I was going to say, I'm sorry, jumping in there, but I'll just add that examiners and supervisors can always look to transfer a case, right? To move a case if it's not their subject matter. So just like it is today, where people can move cases, it'll be a different process moving forward, but the idea is that if it's not the right case for somebody, that person will not be examining it. So for any reason our system is not as accurate as we hope and think it will be, we'll be able to make those manual adjustments.
Okay, I have two questions on that, because the question I always wind up getting about that is well, do the applicants have the ability to ask for a change of examiner because they think they've gotten the wrong art unit, which I suppose now getting in the wrong art unit is going to be completely irrelevant. It'll be just being signed the wrong examiner, right?
Yeah, so people do have the ability to ask. There's a petition process for that. It is, I'm not aware of any time we've actually changed because somebody thinks it's the wrong examiner technology-wise, right? Usually when people are asking, it's because they'll say there's been a problem in prosecution or something like that. So it is a rarity that we do change the examiners, to be blunt, but it certainly has.
And that's what I always say. And just so, and make sure I'm giving folks the right information, Drew, is you have an extraordinarily high burden to change the examiner, right? It's almost got to be, the cases I'm familiar with, there was really almost malfeasance on the part of the examiner, right? Like there was documented bias or maybe almost racial or sexist comments or something extraordinary like that, right?
Well, I'm not aware of any of those situations occurring, so hopefully that's not the case ever. It is a petitions process, and I can't articulate the exact standards here. I do agree with you; it's a high bar, but I think I can't. I wouldn't want to make people be trying to dive into specifics.
Well, and that's fine, because the Office of Petitions, do they fall under you, or they're sort of independent on their own, right?
No, the office. So petitions at PTO are handled in two different ways. There's a separate office which would handle these type of petitions, and then some of the petitions are handled in the CC, and that they're all in my purview.
Okay. Yeah. All right.
I limit myself to one more question, but I think somebody asked this, and I do think it's interesting. Is one of the considerations whether or not an examiner has handled a lot of applications for a particular company? Because I could especially see for a small company that operates in a really niche space that all their applications could end up going to the exact same examiner. And so is there any way that you guys would account for that?
Yeah, because that could either be really good or really bad.
And that's interesting. Right now, I'll be honest with you, right now, all of our matching is pretty independent of who the inventor, who the assignee. We don't even really, I don't think we look at that very much at all. Something we could certainly think about and consider how it would impact, but it's not something we're doing yet.
Yeah, no, I don't know. I'm not sure which way that goes. I was just curious because I could see that happening, where a single examiner basically has all the applications for an entire company.
Yeah, well, that could be good. And it also, let's face it, there are some patent attorneys and agents out there that we are engineers at heart and scientists at heart. Communicating is not necessarily our strongest foot, so to speak. And the way I said that is probably obvious, makes it obvious. You can really develop some kind of friction between examiners. So that can be a real issue if that were to happen.
Yeah, I can also see people now requesting that they work with Joe or something when they file their application.
Yeah, we've already got that question here, is can you ask for a certain examiner, like reserve a table?
Yeah.
So, all right, well, I think that's all we have. Do you guys have anything else you want to say before we move on to Matt?
Thank you very much.
All right, great. And next is Matt, you're up.
So thanks, Gene. I'm going to turn away now from what we're actively doing for CPC that Jay discussed and start talking about some of the next generation tools that we are targeting and where we have development programs underway. So artificial intelligence research and implementation can advance national priorities for intellectual property by ensuring that it contributes to strong, predictable, and consistent IP rights. And agency leadership has championed leveraging artificial intelligence to leapfrog our current capabilities for business processes and a few other use cases. The USPTO has been very busy as of late laying foundations for rapid implementation of useful and reliable AI systems. And as we move towards implementation of artificial intelligence, we do envisage that there may be corresponding shifts in the way that we do business, because we seek to couple the strengths of this technology together with the strengths of our employee for the benefit of the IP system. So you can flip to the next slide. So this is actually reflected in our strategic plan, which supports leveraging artificial intelligence to advance our mission of fostering innovation. I'm going to share some of the efforts that we're undertaking today to leverage AI to make improvements to our processes. I'm going to explain some of the strategies that we're employing to navigate the challenges of employing this particular technology. I would note that my comments today are focused on patent classification, but we are also actively exploring important use cases in the trademarks area, and I wouldn't want to overlook them as well. But before I get into the topic, I wanted to first make a comment about artificial intelligence and the definition. We often get asked, what is artificial intelligence? And I think the answer to that question largely depends on who you ask and the particular use case that you're attempting to apply the technology to. Broadly speaking, it references computer systems that are able to perform tasks that would normally require human intelligence or human intervention. And so if you think about it from like the science fiction perspective, you may envisage robots that are very human-like. But from our perspective at the USPTO, we take a very expansive view of the technology as a tool that we can leverage to improve agency operations and streamline processes. So this includes our development capabilities around things like machine learning, which can be both supervised and unsupervised, natural language processing, using deep learning or neural networks, and those types of technologies. So these are well-established technologies. And again, we take an expansive view about what artificial intelligence is. We also very much take the view that implementation of AI is an augmentation tool to assist with increasing our quality and efficiency for our examiners and the agency. And I'll talk about the patent classification use case in the next couple of slides, so you can move forward. So one interesting AI technique that's quite mature in this field is what's called machine learning. And with this technique, a data scientist can expose the computer system to a large number of examples from different known categories as what we call training data to build a machine learning model. And these examples can be anything that has a lot of information associated with it. So it could be things like photographs, if you're interested in some sort of image recognition technology or capability. It could be financial information if you're in the banking sector, or it could be patient records if you worked in healthcare. And the computer takes all that information that's associated with each of the examples that it was provided, and it looks at that and tries to find patterns in the data that are associated with each of the particular categories. And so this creates a trained machine learning model. And then using that model, you can give the computer a new example and ask it to predict an appropriate category based on the patterns that it's discovered. So clearly the advantage of this approach is that the logic for every single decision within very complex systems doesn't require explicit instruction to be built directly into the computer. And the machine can sift through impossibly large data sets and discover patterns that would be very difficult for programmers to reasonably accomplish by hand. Additionally, computers are very good at detecting very subtle patterns that are deeply embedded in complex data sets. And as Jay had explained earlier, the USPTO uses CPC to classify the content of that's disclosed in patent applications. And as Drew noted, we're expecting more than 450,000 filings this fiscal year. And so handling such a large quantity of patent applications requires significant resources and people to do the intellectual work of actually applying those classifications. And all of this makes for a very compelling use case for us here at the USPTO, especially when you consider that there's tens of millions of patent documents that have already been classified in CPC over many, many decades. And this provides us an enormous amount of training data that's useful for developing and validating an AI-based automatic classification system that can both suggest CPC symbols for patent documents, but also, as Jay had alluded to earlier, potentially identify those symbols that are most closely associated with the claim subject matter. And we view the maturation and operationalization of an auto classification system to offer a variety of potential benefits to the agency. So the first is that the subject matter be thoroughly classified. Unlike a human, an auto classification system can consider all the text of the disclosure against all possible classification combinations. And that auto classification system can provide a variety of predictions for the CPC symbols that might be best appropriate for that given content. The second is consistency in the way that those symbols are assigned. If you had an automatic system, it would act as a single point or a single classifier for all documents, which could potentially reduce the differences in opinion that you might get from different human classifiers about the same content of an application. And we hope that these features could also support quality assurance processes that we undertake here in the agency, since the AI can potentially help the agency more quickly and more thoroughly evaluate the CPC symbols that are already on patent documents. And finally, we foresee the potential to realize operational efficiencies that may in the future help us to reduce some of the resources that the agency has to commit to the classification activities to ensure that we're maintaining good quality. So if you can move the slide forward. So there's a couple of challenges that we face with utilizing artificial intelligence for this particular use case with CPC. And I wanted to get a little bit more, have a little bit more information here to kind of contextualize that for you. And the first is complexity. The CPC scheme contains over 260,000 symbols in it, and they all have distinct subject matter. Sometimes, however, that subject matter and those distinctions between the symbols can be quite subtle, even for our most experienced practitioners. And so there's rules and guidance that set forth what the scope of each symbol is to help users around the world interpret the scheme consistently and apply symbols on patent documents consistently. There's also it's a deeply hierarchical structure that has up to 12 levels of indents in certain portions of the scheme, particularly in well-developed technologies. And these challenges can be very tricky for an artificial intelligence system if we do not appropriately account for both the scheme guidance and the hierarchy. An auto classification system without that information that was purely just trained on the patent documents themselves might, for instance, suggest both a parent and child symbol due to the similarity of the content. And so those would be two different symbols that have very, very closely related subject matter. And this could cause a conflict with classification rules. And so in response to this, our design is looking at ways to consider the scheme guidance through the model training, and as well, if necessary, also augment the system with explicit logic to account for these issues. The other thing that Jay noted was that CPC allows for multiple symbols to be allocated to any particular patent application. And so an auto classification system can't simply suggest the most pertinent single symbol. Instead, it has to be capable and sophisticated enough to be able to recognize when the patent document needs multiple symbols. And we're working on ways to account for this as well. So you can go ahead and flip forward. We have built a prototype system here in the agency using artificial intelligence and some of the techniques that I discussed earlier to suggest CPC symbols for US patent documents by looking at the text as well as indicators for claimed subject matter. And while we're not yet using the system for our actual patent applications, we do hope to mature the system to the point where we're able to use it in the future. As I noted earlier, the advantage of using a system like this is that the logic for every single decision does not require explicit instruction to be built directly into the system by programmers. And so our system can actually predict CPC symbols without human input. Due to the complexity of the scheme and the auto classification system, despite that complexity, we have been able to demonstrate that it does operate fast enough in order to keep up with the amount of patent documents that the USPTO publishes each week. And so that's a big success for us because the systems themselves are very, very complex. Additionally, we're very aware that artificial intelligence systems can sometimes be perceived as a black box where the end users have difficulty understanding the results. And anticipating that this might be a drawback with such systems, we're also prototyping features that provides transparency into the way that the system operates to enable users like examiners to be able to interact with it and understand those results. And we refer to this as explainable artificial intelligence or explainable AI. And the decision-making of the underlying AI models is actually exposed and contextualized for users. So one example of this that we're testing now is to show the examiners the actual portions of patent documents that are most closely linked with each of the symbols that the machine predicts. and this would also include the claims. And finally, we understand the need for the system to evolve as technology changes and also to improve its accuracy over time. And so we've designed in ways to capture feedback from our examiners and classification experts in order to be able to refine the system. We have plans to capture this feedback passively by tapping into the internal CPC quality assurance processes that are already in place and that will be in place in the future. And by doing so, we hope to be able to avoid incurring significant additional costs to make those adjustments and improvements to the system. So you can move to the next slide. And in this slide, I'm going to discuss some of our current activities. Thank you. So as both Drew and Jay made very clear, the quality of classification for patents is extremely important for our operations. And therefore, we are proceeding with a very diligent and data-driven approach to assess and mature the system. We will only be operationalizing the system to apply CPC symbols on actual patent applications when we reach and sustain quality thresholds that are necessary for us to maintain good operations and maintain our quality. And our evaluations of the system are currently ongoing. Based on the early analyses to date, as you might expect, we've found some examples where the tool produces suggestions that are very, very close to the classifications that are already assigned to the patent documents. And in many of those cases, they actually overlap with the content that's on those patent documents. And we've also found some other examples where the tool appears to suggest output that's divergent from the classifications that are already assigned to documents. So in order to understand the reasons why, we have classification experts that are performing intellectual validations on output from the system. And in some instances, for these divergent examples, they've come back and reported to us that the symbols assigned by the auto classification system are actually better or more complete than what's currently available. And then in other instances, they report the opposite, where the currently available classifications are actually better. But they also report that they can see why the machine is making certain determinations in those suggestions. And so in response to this, we provide this data to our data science team and our developers as feedback to iteratively update our AI models. And we're also very sensitive to make sure that we're testing for, detecting, and correcting any sort of unintended biases that might result in the system from the training itself, in order to ensure that we aren't either overusing or underutilizing portions of the scheme when necessary. So as we continue to move forward with this system and development activity and we achieve various performance indicators, we'll continue our integration processes of the auto classification system with our other IT systems that are needed to support CPC in our operations and take further steps towards operationalizing the system within the agency. So I thank you very much for your time, and I think we have a few minutes for questions.
Yeah, this has just been fantastic, and we have so many questions, and I have so many questions. So what maybe we'll have to do is follow up and try and maybe do an article or something to answer some of these, like questions, as many of, and take some of the ones that we've already asked and put them into like an article for people, because people are really fascinated by this and have very good and directed questions. And I have some like overarching questions that just keep popping in my mind. I mean, one of the ones, and I don't know, maybe this is going to be wind up for Drew, is over the years, one of the things that has really concerned me about examination has been what I have perceived at times to be, different treatment from different examiners, and that may not be completely fair in a vacuum to say it that way, but there are certain examiners that have I think we could probably all agree, have a higher allowance rate than other examiners. And I wonder whether that's going to get considered, or as this gets rolled out, how are you going to be in a better position to take a look at that? And how, I mean, I know SPIs have influenced that a lot over the years. I mean, have you thought about how that's going to play out when you're kind of grouping examiners by technology compared to the application versus just within an art unit?
I'm not hearing at all. I missed about 90% of that question. My apologies. I was also not being able to hear the end of Matt's presentation, and I don't know if that's just on my end or others. I think your question was about consistency of examination, from what I can tell, and different treatment, and you're nodding your head, I can see. So to me, of primary importance is the training of our examiners. And when people ask me what's the most important function that we have at USPTO, it's making sure our examiners are trained. So whether that's through trying to have good guidance, like the subject matter eligibility guidance that we've put out in the last couple of years, or we're revamping our training process, this is all foundational to how we move forward. I will say that I hear from people that, hey, this art unit has a higher allowance rate than that art unit, and my answer to that is sometimes, well, maybe that's because of the technology is different, and it should have a higher allowance rate, because I think we can all recognize that some areas are more challenging to get allowances, and it's not because of the examiner. But that being said, I'm not trying to push this all to different and technologies. I think it's very important that examiners have a consistent practice. Some will reach out, for example, more with interview practice than others, and more trying to reach agreement. But that is a fundamental piece to how we move forward to make sure that examiners are consistent. And I'll apologize if I didn't answer your question exactly, but again, the sound was really breaking up.
Yeah, no, that's good. I mean, I was just wondering, and we could talk more about that. So Jay, if cases are going to go to the most experienced examiner, how do new examiners get cases? I mean, how are you going to assign to junior examiners?
That's a great question, right? So I think, as you explained, the predominant way that we train now is that a supervisor or a primary examiner does the training of the examiner. That's the most hands-on. We give a lot of lectures and we have a lot of training classes, but really the day-to-day review of work is done in an art unit by a supervisor or a primary. Our plan would be for a brand new examiner to model a primary or another or two primaries portfolios, give those to this examiner so that those cases get routed to them. And then as a result, the person who's training them will be very familiar with the work that this examiner got as well. And most of the time when we do our modeling, we'll do our modeling to determine what area or what kind of portfolios need work. We put examiners where there is an excess of work. So that way we make sure we're not taking work away from someone else, but we're giving it to someone who can train them, provide assistance, look at the work, review the work, all of that stuff. So yeah, we're going to model for new examiners that of other primary examiners who they're working with.
Okay. And then what are you going to do if an examiner would leave mid-prosecution? How are those cases going to be reassigned?
Yeah, right now, and our plan is the supervisor, like it's going to be the same process that we have today. So a supervisor of that examiner would pull up those cases that have already started prosecution and would find examiners that could take that work. We will give them tools, so we can give the supervisor tools to say, hey, based on this work, here are some examiners that have high similarity to this work, but that's going to be that will likely be an intellectual exercise performed by the supervisor and a collection of supervisors to identify the right matches for that work.
Okay. Megan, do you have any?
And that's the same thing that's done today, Jim. That's the way we do it today.
Okay. Megan, do you have any questions?
I could talk about this forever, but I'll ask one that I think might summarize what a lot of people are wondering about from Matthew's presentation. So there were a lot of specific questions about the AI and how it was going to work. If and when this ever is implemented, will the AI algorithms be publicly available to people?
That is a question that's still under consideration. We're quite a ways away from operationalizing some of these algorithms. And so as we continue to move forward with the development of that, we're actively exploring those questions about how we're going to utilize these both for the agency and potentially what the intersection points would be for the public as well.
Okay. All right. right. And then one final question, and I know this is a tough question since this stuff, I think, Drew, you said, you mentioned that a lot of these AI implementations are aspirational at this point, but do we have any idea of when we might be able to, or when you might be able to implement the AI algorithm for classification for the application of CPC codes?
I don't at this point. As Matt said in his presentation, we have a prototype and there's still much work to be done on that. We've seen some early successes, I think, enough to be encouraging, but we have not progressed to the point of having a date yet.
So here's a quick one. I'm looking through here and seeing we're getting a lot of strategy questions and drafting questions. And Megan, I think we're going to need to follow up with a webinar on that. And I know the patent office doesn't offer advice on strategy or drafting or offer legal advice. So I won't ask you guys those questions. But will the CPC have any impact on restricting claims into different groups?
So the high level answer to that is no. Anything that we are working on now with a new routing scheme does not change any practices with regard to restriction. We're always looking at that, and quite frankly, I know that's a hot topic issue for many people, but what we have talked about should have no bearing on what an examiner does with regard to restriction.
Okay. So another question here. I mean, just quickly, do you think this is gonna, and this is more of a budgetary question, is this gonna provide some cost savings either now or once you get into the AI implementation?
I think absolutely the idea is if you can have a more efficient automated process that takes people away from having to do a task, it would certainly lead to savings. Now, as I mentioned, we don't have a date, and this is all aspirational. And my goal today was that you hear, from Jay on what we are doing and some great steps that are moving ahead, and from Matt about things that are potential for the future. So if we reach that potential, by all means, I do believe there would be a cost savings.
Here's another one I think you guys could probably answer. Do you think that examiners, by going down this path, are going to wind up with a wider field of expertise, a more narrow field of expertise, or is it going to be largely unchanged?
You want me to take a stab at that? Or? So
Sure.
What's interesting about this that we think and doing some modeling is it becomes a little bit, I mean, I like to analogize to a little bit of a supply and demand. So in an area where you have lots of, we talked about finding how many qualified examiners there are for an application, and then how many qualified applications there are for an examiner. In situations where you have a perfect match, there will be little change. In situations where you have more qualified work than you have examiners, then those examiners will tend to get a little more narrow as we bring in other examiners to help do that. These examiners will narrow. In other situations where you have more examiners for work, and that happens all the time, right? Technologies fade and new ones emerge, and we're always looking for ways to make those kind of shifts. And I always laugh. The people, when one of our colleagues tells a story that when he first got to the agency, he was in a group of 100 people who did 35mm cameras, and there was 2 guys down the street that did like cell phones. And you can imagine now it's completely different. So as technologies are always emerging, we're always looking for ways to say, how do we adapt and how do we shift? So in situations where that happens, then those examiners will be able to use their portfolio to find other work they're qualified for, but they would naturally have to broaden because their technology is shrinking or fading or whatever you want to call it. So I don't think there's one answer that says this will happen to everyone. It'll really depend on the makeup and the complexion of that area. And we think that's part of the think that's an exciting kind of dynamic piece of the system that we're pretty anxious about.
Yeah, and I always like to tell you whenever I can, a shout out to Kyle, my friend Kyle, who was the examiner who he's long since retired, but he issued the first MRI patent, and nobody at the office at the time had any experience in anything at all like MRI machines, So the technologies change over time, and it requires examiners to become well-versed in things that heretofore had never existed. And that's what we want, really. You know, incremental innovation is great, but paradigm shifting innovation is fantastic. You know, that's what hopefully we're looking to achieve. Megan, I'll ask one more question, and if you have anything that you want to wrap up with, that would be great. But this kind of goes off the books from what we're talking about, and I know the answer here, Drew, but I hear from independent inventors frequently as because of the pandemic, and they filed provisional applications, and now they're creeping up on their 12 months, and they've had no time really to test the market or try and get licensing deals or do anything because of lockdowns all over the country. And they're hopeful that the patent office will extend the 12-month time limit in which they can file a non-provisional application. And the answer is not good for them, right?
Well, actually, we do have a notice on this exact issue, I believe. I want to make sure that I get this accurate, but this is something we've heard from many folks. So I would feel more comfortable to go back to that notice and make sure I answer and follow up with you, Gene. But this is actually something we did hear, and I do believe we were able to address. And it's
really?
right on
Okay,
our website.
Good. Oh, good. Well, so I'll look at that then, because I had been telling folks that I didn't think there was anything you could do because it was statutory. But so maybe the CARES Act did do something.
I think the CARES Act gave us the ability to waive deadlines, and so this is an issue we did address. And I'll apologize that I'm not having some of the particulars in my head at this point, but I'd be happy to follow up.
Oh, excellent. Okay, so then the takeaway is take a look at the USPTO website. Go search the USPTO website for that, and we will also follow up with that on IP Watchdog as well. Megan, do you have any final question before we give everybody a chance to give their final thoughts today?
I have so many, but in the interest of time, I'll let us move on to the final thoughts.
Okay, yeah. Well, this really provoked a ton of questions, guys. And I don't know whether you would have interest in, after this rolls out, maybe we can reprise this and, you know, we can come and talk about how it's going and so forth. But I really appreciate a fantastic presentation. But let's go in the same order as we started in. And we'll start with you, Commissioner. What is the one takeaway that you would like everybody to leave the webinar here today with?
Well, I'll go right to where I started in the opening, is that we will continue to reevaluate ourselves and see how we can continue to do a better job for all of our filers and all of the public. And I think you learned today of some fundamental changes we're making that I think will make the system better. And we're going to continue to look at ourselves.
Great, thanks. Jay, what your parting thoughts?
Yeah, thank you. From my perspective, I think it's exciting to get to share the changes. We've been working on these for a long time, so it was really fun and exciting to get to share them with you guys. And again, from our perspective, we really hope that that as a result of this change, you see even increased quality or even better quality, and that you take away that that's something that we were really committed to throughout this entire process, was just a real commitment to maintaining the institutional knowledge of the examiners, the technical expertise that they bring in examining patents, and we hope that this just makes it better and helps provide even a better experience for you all. I hope this is a positive for everyone.
Great, great. I'm optimistic. I think that this is going to be a good change, and I can't wait till we get some data to really take a look and verify that. Matt, your parting thoughts. What does the future hold? Look into your crystal ball.
Yeah, I go straight to our mission of fostering innovation, and I think that we take that to heart here at the USPTO, and we seek to innovate, as you heard from Jay, as well as some of the things that we're looking for in the future as well. And as we go through that process, we're always looking to make sure that the way that our innovations are implemented here at the agency is for the betterment of the IP system at large.
Yeah, great. Well, thank you. And Megan, I'll give you the final word here today. I suspect your brain is kind of blown like mine is. I mean, we have a lot of talking to do about all this, to digest it.
There's a huge impact for practitioners. Like I said, the classification process, it impacts who the examiner is on the application, and that obviously has a huge impact on what happens to that application. So there's definitely a lot we can talk about in terms of practical applications, but overall, I think this is a fantastic move. I think it's going to result in higher quality applications because they're going to get in front of the right person.
Yeah, I think that that's exactly what we're going to see as well. And while it wasn't appropriate to get too deeply into it for this webinar, as you probably all know, LexisNexis has been a great supporter of mine and lets me pick the webinar topics that I like to do. And we do an awful lot of strategy and drafting, and we've got a lot of things to follow up on now about best practices moving forward. And we will continue to do that as a part of this webinar series. So thank you for joining us here today. Thank you, Commissioner. It's always good to see you, even if it's just virtual. Look forward to seeing you all in person once the pandemic makes it safe. You all in the audience, thank you for joining us. Please stay safe and healthy and have a good rest of the week and a good weekend. And we'll see you soon, hopefully.
Thank you.
Thank you for having us.